Okay. And what is she doing?
My sister.
This was a horrific crime.
Absolutely horrendous and disgusting to look at. I am unrecognizable in those photos.
You've come into this court on 2 occasions in which you've barked like a dog.
Corey Richens is facing charges for the alleged poisoning of her husband, Eric Richens, in March 2022. The case revolves around accusations that she fatally poisoned him with 5 times the lethal dose of fentanyl. During a recent motions hearing in Utah, the court addressed several issues related to the case, including motions from Richens' defense to reconsider her bail conditions and to separate certain charges.
We do believe that as far as the attempt charge goes, that the key things to look at are the fact that it is being used for character. I don't see how...
Tell me why you think that is the conclusion the court should draw here?
Well, it's so intertwined with propensity. How do you unwind that, right? Like, it's completely intertwined with propensity. So the argument being that, well, she did it, if she did it before, she must have done it again, right? And so that type of prejudice is just devastating to a defense, and it's based on zero evidence. There's no evidence of it.
The court determines that the danger of the jury defaulting to a character-based or propensity-based inference that defendant is a liar and a cheat, so she must have committed more crimes in January through March of 2022 is simply too high. Defendant's motion to sever counts 5, 6, 9, and 10 is granted.
After the hearing, Richens' defense attorney issued a statement noting that with 2 charges dismissed and 4 others severed, they felt more confident about the narrowing of the case against their client. They believe that this process is exposing weaknesses in the prosecution's case. Richens' trial is set to begin in April of the next year. On April 6, 2019, 9-year-old Kyle Allwood allegedly started a fire that claimed the lives of 5 family members in their mobile home in Goodfield, Illinois. Kyle and his mother were the only survivors. 6 months later, Kyle was charged with 5 counts of first-degree murder, 2 counts of arson, and 1 count of aggravated arson. During his court appearance in October 2019, Kyle struggled to understand the legal process, and the judge had to explain things to him. He left the courtroom crying with his arms crossed. Because of his age, Kyle cannot go to prison if found guilty. In Illinois, which is one of 33 states without a minimum age for criminal responsibility, he could face about 5 years of probation, with his punishment ending when he turns 21. His sentence would probably include therapy, counseling, and a psychological evaluation. Kyle's mother, Katie Allwood, defended him, saying he is not a monster and that everyone makes mistakes. She also shared that Kyle has been diagnosed with schizophrenia, ADHD, and bipolar disorder.
Everyone is looking at him like he's some kind of monster, but that's not who he is. People make mistakes, and that's what this is. Yes, it was a horrible tragedy, but it's still not something to throw his life away over.
However, other family members are calling for a harsh punishment. Hannah Payne, a 25-year-old woman, was sentenced to life in prison with the possibility of parole for the 2019 act that resulted in the demise of 62-year-old Kenneth Herring in Clayton County, Georgia. Payne was convicted of several charges, including felony murder, malice murder, aggravated assault, false imprisonment, and weapons possession. The incident occurred when Payne followed Herring after a crash he was involved in, which she was not directly part of. Payne claimed she was trying to assist by gathering Herring's license plate number for the police, as she thought no one else had done so. Payne testified that after she followed Herring, he stopped his car, and when she approached him, he grabbed her shirt and wrist, pulling her into his vehicle. She felt threatened and said she saw her life flash before her eyes. At that moment, she believed Herring was reaching for something behind his seats, so she pulled out her weapon and fired at him.
And when you got on the phone with 911, you stated that he pulled the trigger?
Yes.
And what else did you state?
To her, I had told her that he had just pulled the trigger. And I remember kind of looking around and I noticed behind me that there was someone who was standing behind me, and I asked them if they seen everything, if they would stay to, be a witness. And he was asking, like, if we were okay. He's like, are you okay? Is everything okay? And I told him, I am, but no, he's not.
However, the prosecution argued that Payne acted out of revenge and not self-defense. They contended that Payne was playing cop by pursuing Herring after the crash and that she fired at him when she cut him off. Despite the defense's claim of self-defense, the jury convicted Payne of murder, and she was sentenced to life in prison with the possibility of parole. Clark Frederick's case took place in a New Jersey courtroom, where he appeared before Judge Thomas J. Critchley. His story was unique. Frederick wasn't just another man accused of murder. He was a man seeking justice for the terrible experiences he said he went through as a child.
Dennis Pegg told me that he had sexual relations with a close family relative, and also my childhood friend Jeff Hall. He described those relations in detail, and I believed him. In the spring of 2011, I saw Dennis Pegg with a boy who was about 13 or 14 years old at a Quick Check in Newton. He told me that he got drunk and naked with one of my close relatives.
Frederick had been abused by a former Boy Scout leader, Dennis Pegg, for years. Pegg was someone Frederick had once trusted and admired, but the abuse left him deeply hurt. The pain and trauma stayed with him throughout his life, building up anger and rage over time. Everything exploded on June 12, 2012.
Dave Carlin reports on the case that has many asking, was Clark Fredericks right or wrong?
On that day, Frederick couldn't handle it anymore. Driven by memories of his abuse, he and his friend Robert Reynolds went to Pegg's house with a knife. Frederick confronted the man who had taken his childhood. What began as a confrontation quickly turned violent. Frederick repeatedly stabbed Pegg, ending the life of the man he believed had destroyed his.
It started out with him wanting to touch my scar that I had from open heart surgery at the age of 6.
After his arrest, Frederick did not deny what he had done. He was honest about his reasons. In a heartfelt statement in court, he said, "I did what I felt I had to do to stop the nightmare." His voice trembled as he spoke about the years of suffering and how no one had heard his pleas for help. He explained that his actions were out of desperation, not revenge.
The trial started for serial child molester and former Penn State coach Jerry Sandusky.
My reaction to seeing Sandusky get out of that car with his lawyer was that Dennis Pegg would never be held accountable. My shell cracked.
Judge Critchley faced a difficult decision. On one hand, Frederick had committed murder, but on the other, a lifetime of pain had brought him to that point.
But his guilty plea on charges of passion, provocation, manslaughter avoids a murder charge. As he left the courtroom, this eruption of applause.
For coming out and standing up for himself.
No one related to Pegg made any public statements. The prosecutors who agreed to the plea deal hope this brings closure.
And we feel it is a fair and appropriate result, given all the circumstances.
The judge said the sentence, anywhere from 5 to 10 years in prison, will be announced in September.
In the end, the court accepted a plea deal. Frederick pleaded guilty to manslaughter, a lesser charge than murder, admitting that although his actions were driven by trauma, they were still wrong. Ronald Gregory, 68, pleaded guilty but mentally ill to the murders of his wife, Barbara, and his granddaughter, Mia Rogers, in March 2021. Gregory admitted to firing at his wife while she slept. Afterward, he went into Mia's room and fired at her as well. Mia, however, did not pass away immediately. She lingered for about an hour, during which she asked Gregory, "When will I stop hurting?" Gregory did not attempt to seek medical help for her. The prosecutor, Solicitor Kevin Brackett, described the murders as ghastly, particularly noting the tragic final moments of Mia, who lost her life at the hands of her grandfather.
I've been representing Mr. Gregory privately in civil matters since October, so he and I have a good working relationship. He has always indicated in this matter he did not want to hire an attorney, and I've explained to him my job is to help him. If that's what he wants to do, I'll help him carry out those wishes. If he decides he wants to hire an attorney, we will hire an attorney for him. All the discovery so far has been delivered to Mr. Gregory through me. I have reviewed it. I reviewed it with Mr. Gregory and let him know what the discovery shows. At this point, he's telling me he still does not want to hire a criminal attorney, but he also says he's not sure.
But I can tell you that it's very dangerous for an individual who is not an attorney to face any charge, even shoplifting charge from carries 30 days in jail. Particularly dangerous for someone who is charged with 2 murders and is facing life imprisonment to represent themselves if they're not an attorney. Do you understand that? Do you understand an attorney could be a benefit to you? They're certainly very involved and technical. They trip me up sometimes, and I've been doing this for 20 years and practicing law for over 40. There are technical legal matters and motions that can be made, discovery that's already been discussed today. There's questions about mental situations. There are evidentiary issues that may arise. I can even catalog for you a number of legal issues that exist in a case such as this. But I can tell you that an attorney would be a benefit to you in handling those issues because an attorney would be trained, skilled, and used to having those. And for you to take those on yourself would be very dangerous. You understand that? You do understand the benefit of having an attorney? Yes, sir, I do. And you understand that there's danger in going forward without an attorney. Do you have any questions about where we are in this case at this time, today?
Where do we stand right this time?
Well, where we stand right now is
being charged.
Big part?
Being charged or being?
Well, I'll have to ask the solicitor a little bit about that because I know you've been arrested. Obviously, you're in jail. The warrants have been issued. I don't know whether or not you've been indicted and when those indictments have gone to the grand jury. I don't know whether it's been in their hearing. But let me get the procedure where we are procedurally from the solicitor if you don't mind because I don't know.
Yes, sir. Your Honor, the case has not been indicted. We have not received a request for a preliminary hearing in this matter, so we have not scheduled one. If we did receive a request for a preliminary hearing, we could certainly make that happen. No, sir, we're prepared to move forward with this case expeditiously. I think the next impediment, or the only impediment that is in our way right now, is resolving the issue of mental health, knowing that there isn't an issue there, because that could obviously take the case in a different direction. But once we've resolved that issue, if there are no problems there, we're prepared to move forward.
The victim's maternal grandfather, Paul Rogers, expressed horror at the events, calling them inhumane. The day after the murders, Gregory attempted to end his life by hurting himself, but after realizing he was still alive, he tried again. He survived the attempt and was hospitalized for 5 days. Gregory later told detectives that he had been contemplating taking his own life for weeks and decided to end the lives of his wife and granddaughter because he didn't want to leave them without anyone to take care of them. Dejon Anderson, 38, is facing charges for the 2022 loss of her son, Cairo Jordan, who was found in a suitcase in a wooded area of Washington County, Indiana. Anderson was arrested in California and extradited to Indiana for the crime. She is charged with murder, neglect of a dependent resulting in fatal harm, and obstruction of justice. The case gained attention due to the horrific nature of Cairo's passing and Anderson's actions before and after it. In a recent hearing, Anderson appeared in court and requested to represent herself, claiming she was a sovereign citizen and rejected the offer of a court-appointed attorney. The judge warned her that representing herself could be detrimental to her case and ordered a public defender to be assigned to her.
I have been under NSA surveillance for the past 8 months, and how can that qualify me as a fugitive on the run when I've also had a detail from Space Force that was following my every move when I contacted the Indiana State to arrest me?
That is not a valid legal objection. If you want to represent yourself, you're going to have to learn the rules of evidence and the rules of procedure, because if you conduct yourself like this and make these types of objections, you have no chance in the world, baby.
Okay.
So, objection overruled. But I will let you make argument in regards to bond.
Okay. Well, thank you. So that's my argument is that I have been under surveillance by NSA for over 8 months. I also have a detail that follows me everywhere I go from Space Force military. I also contacted Indiana State. I think it was a federal marshal that I called to have my location tracked to pick me up. So there's no type of extent of me running where I need this astronomical bond on my charges.
Well, that's sort of interesting because it's my understanding Officer Busick has been in touch with almost every one of those agencies and they haven't been able to identify your location until recently. So I'm going to set your bond at no bond at this particular point in time. If Space Force comes forward and tells me that they're willing to monitor you, we'll take up the issue of bond at a later time.
Okay.
Anything else?
No, Your Honor.
All right, we'll be off record at 1:44. You can, she's remanded to the custody of the Washington County Sheriff's Department.
Thank you, Judge.
Thank you.
You're welcome.
The details surrounding Cairo's demise are deeply troubling. He had been left to suffer, and according to statements made by Anderson's co-defendant, Don Coleman, Anderson had been found on top of Cairo in a compromising position before the child's body was placed in the suitcase. Coleman helped Anderson dispose of the body in Indiana. Coleman was arrested and pled guilty to charges of aiding and abetting the murder, and she will testify against Anderson. The case remains under investigation. Meanwhile, the community continues to rally behind Cairo, with many people showing support for justice in the courtroom. This is Deborah Milke. She was sentenced to death and spent 22 years on death row for a crime she didn't commit in Phoenix, Arizona.
During this whole tragedy, I was angry. Of course I am, I still am, but I can't change anything. All I can do is learn how to live with it.
Milke's son was found lifeless in a desert, having sustained 3 fatal wounds. Milke was questioned by Detective Armando Salat Jr., but the interrogation was neither recorded nor reported. He later claimed that Milke admitted to arranging the murder.
She then decided that it'd be best for Christopher Milke.
She was then charged with first-degree murder, even though there was no actual record of her admitting to the crime.
My innocence did not matter in their pursuit of a conviction.
The state concluded that she had orchestrated the attack, and she was sentenced to death. More than 20 years later, doubts began to arise about Milke's supposed confession to Detective Salat, which Milke continued to deny ever making.
Absolutely nothing to do with the brutal of my son Christopher, and I did not give a confession to Mr. Soldate.
It was reported that the court found Detective Soldate had a long history of lying under oath and violating people's rights during interrogations, including Milke's. Her alleged confession was the only direct evidence connecting her to the crime. After 24 years of being arrested and still facing the death sentence, her conviction was overturned. Listen as she shares her thoughts on the wrongful conviction.
Losing a child to murder is a devastating tragedy. Being falsely accused of a crime you didn't commit is also a devastating tragedy. Try to imagine that. What happened to me could happen to any one of you.
A lot of people think that you were responsible for the killing of your son. Anything you can say about that?
To people who still think she's guilty, the Ninth Circuit and the Arizona Court of Appeals both reviewed this case thoroughly. And they said that this was egregious prosecutorial and police misconduct that constituted a severe stain on our justice system.
There are no reports of Milke receiving any compensation. This is Clifford Williams. He was sentenced to death and spent 43 years in prison for crimes he didn't commit in Jacksonville, Florida.
Just wanted to get out and be with my 6 kids. They was gone and it wasn't nobody but them.
Williams, 34, and his 18-year-old nephew, Nathan Myers, were suspects in a murder and attempted murder. The survivor of the incident claimed the uncle and nephew were responsible, naming them both. Despite having strong alibis, Williams and Myers were arrested and charged within hours. There was no physical or DNA evidence linking the 2 men to the crime, yet both were convicted. Williams was sentenced to death, and Myers got a life sentence. It wasn't until 43 years later, while they were still in prison, that a new investigation uncovered key evidence. The ballistic reports from the crime lab didn't match the original testimony, which had been the only thing connecting the men to the crime. Finally, after 43 years, Williams and Myers were granted their long-awaited freedom.
Mr. Williams and Mr. Myers, the indictments have been dismissed against you. You are free to go, and we are adjourned.
Williams and Myers were each awarded $2 million in state compensation for their wrongful conviction and the 43 years they spent in prison. Ryan Burge is facing a serious accusation, causing the demise of Hartley Anderson. It all began when Hartley's mother, Natasha Luchow, found her daughter unconscious with serious head injuries.
Mom's boyfriend, 37-year-old Ryan Burge, was babysitting her at the Madison Park Apartments in Northeast Vancouver. Paramedics were called, and when police arrived, they found Hartley unconscious with severe head trauma.
Ryan Burge, who had been dating Natasha Luchow for just 3 months, was trusted with caring for her daughter, Hartley. However, his explanation for Hartley's injuries didn't add up. He claimed that Hartley hurt herself during a tantrum. His story seemed untruthful to those in the courtroom, where supporters wearing Justice for Hartley shirts filled the space. Emotions ran high as Hartley's father, Peter Anderson, angered and heartbroken, moved toward Burge before being escorted out by security. In the midst of the chaos, someone shouted, "Burn! Burn in hell!" Natasha Luchow, tearful and filled with sorrow, was led away. What exactly did Burge do to cause such pain and anger? On November 2nd, 2018, he was responsible for looking after Hartley while her mother worked and her siblings were at school. They followed their usual routine, which included a trip to the grocery store. However, things took a dark turn when Burge said Hartley threw a tantrum when she came home from school. He claimed he sent her to her room, where she started banging her head against the wall. Around 5 p.m., emergency services were called to the Madison Park Apartments in Vancouver, Washington. They found Hartley with severe head injuries and rushed her to Portland Children's Hospital. Despite efforts to save her, Hartley passed away from her injuries, and Burge was quickly arrested on second-degree murder charges. After the tragedy, many people supported Hartley's grieving family. Colleagues like Lisa Belch handed out black t-shirts with Hartley's picture, honoring her memory.
Never get to see her graduate from high school or be married or anything. He took that from us. He took the joy we had with her away. I just hope the system works.
Hartley's grandfather, Tim Luchow, was overcome with grief. He mourned the moments he would never get to share with his granddaughter, but clung to the hope that justice would be served, seeking some form of closure despite the overwhelming loss. Even though Burge argued that Hartley's injuries were self-inflicted, the neurosurgeon who treated her was certain that her injuries were too serious to have been caused by herself. During the trial, the prosecution argued that Burge had attacked Hartley in a fit of rage, describing his actions as a violent reaction to her distress.
Burge will now face that first-degree murder charge and some other charges as well. Investigators say he injured 5-year-old Hartley Anderson so badly it killed her.
After everything was settled, Ryan Burge was sentenced to 40 years in prison. It was a fitting end for a man who had caused so much harm. In the aftermath of the tragic incident on the set of the film Rust, armorer Hannah Gutierrez-Reed was sentenced to 18 months in prison for involuntary manslaughter in the loss of cinematographer Helena Hutchins. In 2021, during a rehearsal, lead actor Alec Baldwin fired a prop weapon that unexpectedly discharged live ammunition, ending the life of Hutchins and injuring director Joel Souza. Gutierrez-Reed, responsible for ensuring weapons safety on set, was found negligent in her duties, including improperly loading the weapon with live rounds. During the trial, prosecutors argued that Gutierrez-Reed's carelessness and failure to perform essential safety checks allowed live ammunition to be present on set. The defense contended she was unfairly targeted as the least powerful person on the production, highlighting systemic failures and her limited authority. The judge, however, criticized her lack of accountability. Gutierrez-Reed's father, a seasoned movie armorer, attempted to raise funds for her legal defense, but the effort was shut down due to its connection to a violent crime.
I would start with count one. Okay. You both of them. Will the defendant please stand?
We find the defendant, Hannah Gutierrez, guilty of involuntary manslaughter as charged in count one. We find the defendant, Hannah Gutierrez, not guilty of tampering with evidence as charged in count two.
All right, thank you. You may be seated. Let me get those forms, retrieve those forms from you. I'm going to do what's called polling the jury. What I need to put on the record is that this is your individual verdict, okay? So I'm going to start with the gentleman in the back.
Meanwhile, Alec Baldwin, who faces similar involuntary manslaughter charges, maintains his innocence and will go to trial later. Prosecutors argue that as both the actor and a producer, Baldwin holds shared responsibility for the unsafe conditions on set. On a dramatic Saturday, Chad Daybell was sentenced to death by Judge Stephen Boyce, bringing an end to one of the most disturbing cases in recent years. As the verdict was read, he sat there completely emotionless.
It is directed that the defendant would be sentenced to death on those counts.
Chad Daybell was convicted of first-degree murder for causing the loss of his first wife, Tammy Daybell, and 2 children from his second marriage. In addition to the murder convictions, he was also sentenced to 15 years in prison for committing insurance fraud. So what led to this shocking outcome? Let's break it down. The nightmare began in September 2019, when Tylee and JJ were last seen. Their disappearances sparked a major investigation, and in June 2020, authorities made a discovery. The children's remains were found buried in a shallow grave on Daybell's property in Idaho. It was revealed that Daybell and Lori Vallow believed their children were zombies and conspired with Lori's brother to end their lives. But that wasn't the only mystery. Tammy Daybell's passing, initially thought to be from natural causes, was also suspicious. Just weeks after her passing, Daybell married Lori Vallow Daybell, his new wife and the mother of the children who lost their lives. This quick series of events, along with Daybell's strange behavior, raised red flags and led to a deeper investigation into his life and actions. In fact, Daybell had already bought rings and wedding dresses before his first wife passed away. Here's a phone call between Lori, who was already in prison, and Chad while the house was being raided.
Are they in the house?
No, they're out on the property.
Are they seizing stuff again?
They're searching.
Lori was also charged with first-degree murder for the loss of her husband, Charles Vallow, separate from her involvement in the loss of her own children. She was later sentenced to life in prison. The trial of Chad Daybell was incredibly dramatic. Prosecutor Rob Wood portrayed Daybell as a man driven by greed and dangerous religious beliefs. Wood argued that Daybell's desire for power and money led him to plan the murders. The prosecution stressed that these acts were not only brutal, but were also marked by an extreme level of cruelty.
Certain cases that just stick with you. This is going to be one of those for you.
Oh, absolutely, both personally and professionally. At the end of the day, there are victims who senselessly were and that loss and that pain is very real for their loved ones and their families. It's very real for us.
However, Daybell's defense team tried to present a different perspective. Attorney John Pryor described him as a once quiet man whose life fell apart after meeting Lori Vallow Daybell, whom he portrayed as a manipulative influence. Pryor argued that this relationship triggered Daybell's criminal actions, suggesting that his life was turned upside down by this attractive but destructive woman.
I want to talk a little bit about confirmation bias. We talked a little bit about that. It's when somebody starts an investigation or gears them.
After deliberating for several hours over 2 days, the jury reached a verdict. They determined that Daybell deserved the death penalty. The judge agreed, stating that the extreme brutality of the murders and Daybell's fraudulent actions were far more significant than any factors that might reduce his sentence.
This is the best justice we can possibly get. It brings closure for everybody that's been hurt.
Despite the closure, the victim's family still had a great deal of pain to bear. Annie Cushing, Tylee's aunt, remembered her niece as a lively and hopeful young girl whose life was taken too soon. As she read her victim impact statement, both the people in the gallery and the jury were seen wiping away tears.
I am asked about a pet cemetery. And a few days later, I watch with the world as the bodies of 2 precious missing children are found on the same property where my sister died.
Tammy Daybell's father, Ron Douglas, shared his deep sorrow and anger, while Kay Woodcock, JJ's grandmother, talked about the great loss and the dreams that her grandson would never get to fulfill. Daybell's actions caused tremendous pain for the families of the victims. While the sentencing brings some justice, it can undo the hurt. The next case is about a war general who refused to accept the court's decision. Slobodan Praljak joined Croatia's army and quickly moved up the ranks, eventually becoming a major general. By 1993, he was leading the main staff of the Bosnian Croat Defense Forces, HVO, placing him at the center of some of the worst conflicts of the Bosnian War between 1992 and 1995. The Bosnian War was a violent and complex conflict involving Bosnian Serbs, Croats, and Muslims. At first, Bosnian Croats and Muslims fought together against the Bosnian Serbs, but for 11 months, they turned against each other. During this period, the city of Mostar saw intense fighting and atrocities committed by all sides. As a top military leader, Praljak was linked to many war crimes. In the summer of 1993, when soldiers began rounding up Muslims in Prozor, Praljak made no real effort to stop them. He also failed to prevent murders, attacks on international organizations, and the destruction of Mostar's historic old bridge and mosques. These failures later became the basis for his charges. After the war, Praljak went into business, but his wartime actions caught up with him. In 2004, he turned himself in to the Hague court and was released temporarily. However, in 2012, he was ordered back to detention in The Hague. By 2013, he was sentenced to 20 years in prison for crimes against humanity. His case was part of the International Criminal Tribunal for the former Yugoslavia, ICTY, created by the UN in 1993 to hold those accountable for serious violations of international law. Praljak was one of 6 former Bosnian Croat leaders brought to trial for their roles in the conflict. As the ICTY continued its work, the final appeals judgment for Praljak and his co-defendants approached. On November 29, 2017, Praljak and 5 other Bosnian Croat leaders appeared in court at The Hague to hear the verdict. The atmosphere was tense as the presiding judge, Karel Agius, prepared to announce the decision. Praljak, who had always denied any wrongdoing, was about to face the final judgment for his actions during the war.
Affirms the sentence of 20 years of imprisonment, subject to credit being given under Rule 101C of the rules for the period he has already spent in detention. Mr. Praljak, you may be seated.
When the judge confirmed that Praljak's 20-year prison sentence would stand, the courtroom went completely silent. The weight of the moment was clear to everyone present. Suddenly, in a startling and unexpected move, Praljak stood up, his expression defiant. He raised a small glass to his mouth, tilted his head back, and appeared to drink its contents.
Slobodan Praljak nije ratni zločinac. S prijezirom odbacujem vašu presudu.
Le président, notre client dit qu'il a bu un poison ce matin.
Judge Agius quickly stopped the proceedings and asked for an ambulance. Emergency workers rushed into the court building with medical equipment and backpacks. Outside, an ambulance arrived, and a helicopter circled overhead, ready to help if needed. The courtroom, now treated as a crime scene, was filled with shock and urgency. According to a statement from the ICT, Praljak received immediate help from their medical staff. However, despite their efforts, he was taken to a nearby hospital where he was pronounced lifeless. The Florida Supreme Court recently upheld 2 first-degree murder convictions and a death sentence for James Herard, a South Florida gang member involved in a 2008 crime spree. This came as a shock to him, as he had challenged the judge to give him the death sentence, believing the Supreme Court would overturn it and allow him to live.
I'm not asking you to spare me, because I know the Supreme Court, won't allow me to for something that I didn't commit.
Herard was found guilty of 18 gang-related crimes, including the murders of Eric Jean Pierre and Kim Huynh. As the second-in-command of a Lauderhill chapter of the National Crips gang in November 2008, Herard and 2 other gang members roamed the streets of Lauderhill, competing to increase their body count. They randomly came across Eric Jean Pierre, who had no gang ties and was just walking home from a bus stop. At Herard's suggestion, another gang member struck Jean Pierre in the chest, causing fatal injuries that took his life instantly.
They claim that I encouraged the raw bill to do someone. And how I did that, I don't know.
During Herard's appeal, he presented several arguments in his defense, including the claim that his statements to Lauderhill police should have been excluded because they were made after he had requested an attorney. However, the Florida Supreme Court rejected this argument, explaining that Herard voluntarily waived his Miranda rights after reinitiating communication with the detectives. The court explained that when Herard asked for an attorney, the detectives started to leave the room. Herard then began asking questions about his booking and how long it would take to get an attorney. After After receiving answers, he chose to waive his Miranda rights and signed the waiver form, showing he was willing to speak without an attorney present.
Go ahead and do what you're gonna do. Pretty much, you know what I mean? I'm pretty much daring you to give me the death sentence. Pretty much. You know what I mean? Because by all means, because I'm innocent.
His criminal activities, which took place from June to December 2008, included several robberies and acts of violence. In addition to his death sentence, Gerard had already received 9 life sentences from a Palm Beach County judge for a series of violent robberies he committed when he was just 19 years old. He was involved in a string of violent Dunkin' Donuts robberies, so even before this case, he was already facing life in prison. This case gained more public attention because of his strange behavior in court, including barking like a dog.
You've come into this court on 2 occasions in which you've barked like a dog. I don't think you quite understand the seriousness of the charges against you. All right, sir.
In May 2014, Gerard stood trial for 19 felony charges, including 2 counts of first-degree murder, racketeering, conspiracy to commit racketeering, and multiple counts of robbery and attempted murder. His own incriminating statements during police interrogations were key to the trial, where he admitted to organizing the gang's violent acts and instigating the murder of Eric Jean-Pierre. During the penalty phase, the jury voted 8-4 in favor of the death penalty for the murder of Eric Jean-Pierre. For the murder of Kim Huang, they recommended life imprisonment. The judge agreed with the jury's recommendations, citing reasons such as Gerard's past violent crimes, the premeditated nature of the murder, and his gang involvement. Despite the defense presenting arguments for a lighter sentence, including Gerard's troubled childhood and mental health issues, the court decided these factors were not enough to reduce the seriousness of his crimes. Gerard was sentenced to death, and his mother cried. Gerard later appealed to the Florida Supreme Court, challenging several parts of his trial. He argued that his right to a fair trial was violated, that his incriminating statements shouldn't have been admitted, and that expert testimony on false confessions was wrongly excluded. He also questioned whether there was enough evidence for his convictions and whether his death sentence was constitutional. However, as mentioned before, the Florida Supreme Court upheld all of the trial court's decisions. Gerard was going to die in prison. In 2013, Cynthia Varela-Casas of Albuquerque, New Mexico, brutally ended the life of her son, Omari, by kicking him, causing severe internal bleeding. She was sentenced to 40 years in prison after pleading guilty to 6 counts, including second-degree murder. In court, Varela-Casas expressed regret, claiming she loved her son and thanked her sister, Sylvia Marquez, for caring for her other children. Marquez spoke emotionally about the impact of Omari's death, describing the challenges of raising the surviving children, who still struggle to understand their brother's death. A letter from Omari's 7-year-old sister was read in court, asking the judge to keep their mother in jail for their safety.
New Mexico versus Cynthia Varela-Casas, CR 2014-00203. Ms. Varela-Casas, in count 8 of the information, it alleges that on or about December 27, 2013, here in Bernalillo County, New Mexico, that you did Omari Varela and knew that your acts created a strong probability of death or great bodily harm contrary to New Mexico law. Are those allegations true? Are those allegations true?
I will never understand why all this happened, Your Honor. My sister will have to live with that, what she did to her child Omari, and the pain she caused to Nippy and Stevie the rest of her life. We can never get our precious Omari back, but we pray you will be able to help us protect his siblings from any more pain and hurt. No amount of time that is served will bring him back or change anything. Thank you, Your Honor.
Thank you for being here, and thank you for sharing, as painful as that has been.
This is Claire on behalf of Noel. Dear Judge, sometimes
In accordance with the plea and disposition agreement and the terms outlined therein, the court will suspend all but 40 years for an actual term of incarceration in the New Mexico Department of Corrections of 40 years. That will be followed by a term of parole, as well a term of supervised probation of 5 years. Sentence. Anything else from the defense? What will be? All rise.
Initially, Varela-Casas had lied to authorities, claiming Omarie's injuries were from a fall off a toy horse. However, an autopsy confirmed he passed away from blunt force trauma. The sentencing followed her stepfather's earlier conviction on charges of tampering with evidence and failing to call 911. Varela-Casas faced a potential sentence ranging from 15 to 45 years, but received 40 years for the crime that ended Omarie's life and devastated his family. This boy is about to testify in court against his mother. He witnessed his mother drown his sister, and now he will share the details with the jury. To understand the situation, let's go over what happened on August 8, 2008 in the small town of Esto, Florida. Adriana Hutto was found unresponsive in the family's swimming pool. Her mother, Amanda Lewis, claimed that Adriana had been cleaning bugs out of the pool, slipped, and drowned. Amanda said she tried to save her daughter, performing CPR while calling for emergency help. Fire services arrived quickly and airlifted Adriana to the hospital, but tragically she did not survive. While Amanda was at the hospital, her son AJ was with his grandparents, Brenda and Charles Burns. AJ, just 6 years old at the time, began telling a different story. He said that Adriana had sprayed window cleaner on the TV, which made Amanda very angry. Brenda and Charles were stunned by AJ's account and took him to the police for questioning.
Adriana was trying to escape from Mama, and then Mama pulled her back in the car. And then once they got back home, Mama threw her back in the pool. And then she started drowning again.
Adriana started drowning?
AJ was interviewed twice that day by investigators and a child expert. Each time, his story remained the same.
She was upside down in the pool.
She was upside down when you found her? When she landed or when you found her?
When I found her.
He even used gestures to demonstrate how his mother had drowned his sister. He told the same story in court.
And I told them today that Adriana was is going to have to answer so they can hear.
Yes, sir.
His mother had drowned Adriana in the pool.
What is this right here? Who is this, or what is this?
My mama.
Okay. And what is she doing?
My sister.
AJ described how Amanda used her hand to cover Adriana's face and push her underwater.
How is she doing that, AJ?
Putting her hand over her face.
Would you show me how she put her hand over your sister's face? Huh?
Yes, sir.
You don't want to do that?
Yes, sir.
Okay.
He said his sister was dunked as a punishment for misbehaving. The reason...
What did Adriana do that day?
Nothing.
Did she do anything to get in trouble that day?
Yes, sir.
What did she do, AJ?
Spray some spray on the windows.
Oh, yeah? Why was she doing that?
I don't know.
AJ's testimony was graphic and unsettling. He said, she did some things she wasn't supposed to, so my mama got mad and threw her in the pool.
Did you ever go over and see your sister in the pool?
Yes, sir.
Tell me about that. When did you go over there?
I can't remember.
Despite Amanda's denial and passing a polygraph test, authorities remained unconvinced. Over the next month, investigators and the local prosecutor verified multiple details of AJ's story and decided to look deeper into the case. A search of the children's home revealed that their bedroom was filthy and smelled of urine. Adriana, who had ADHD, had been wetting the bed, and the room had no toys, painting a bleak picture of the children's living conditions. The court was shown a drawing AJ had made, showing the events leading up to Adriana's demise. The simple yet impactful sketch illustrated how Amanda pushed Adriana into the pool and held her down. The autopsy report supported AJ's account, revealing a bruise on Adriana's face that had turned into a handprint, matching AJ's description of his mother covering Adriana's face and pushing her underwater. The doctor, who had tried to save Adriana, testified that Amanda showed no emotion when she learned of her daughter's passing. Instead, she asked where the vending machine was, a detail that stunned the courtroom. After a 4-day trial, the jury deliberated for several hours before reaching a verdict.
To count 1 in this case, the defendant is guilty as charged of first-degree felony murder. As to count 2 in this case, the defendant is guilty as charged of aggravated child abuse.
Amanda Lewis was found guilty of first-degree murder and child abuse. She was sentenced to life in prison without the possibility of parole, along with an additional 30 years for child abuse. Marcus Fishburn was sentenced to death for the 2019 murder of Aisha Levy, a 25-year-old woman with a promising future who was the girlfriend of his roommate. The crime occurred in their apartment at Green Tree Place Apartments in Jacksonville, Florida. Levy lost his life during what Fishburn described as an altercation, which left the apartment covered in blood. Her body was found wrapped and stuffed into a plastic storage bin in a closet. The discovery was made when Fishburn's roommate returned home from work and called the police. Fishburn was arrested at a Jacksonville bus terminal as he attempted to flee to Indiana.
Thank you. All right, Mr. Fishburn, I will begin with count 2, the kidnapping charge to which you pled guilty and to which this court will now adjudicate you guilty and sentence you to life in prison with credit for 1,637 days for time already served. The court will assess the mandatory felony court costs of $518 and total public defender fees of $150, and that's $50 for application and $100 for service. And as to count 1 for murder in the first degree, Mr. Fishburn, the court has carefully considered and weighed the proven aggravators and all of the mitigating circumstances. The law requires the court to give great weight to the jury's recommendation that the defendant be sentenced to death, and after assessing the proven aggravating factors and all of the mitigating circumstances, as well as the evidence presented to this court at the Spencer hearing, this court is in agreement with the jury's recommendation. So accordingly, this court finds that death is the appropriate penalty for the defendant given the highly egregious nature of this crime. So, Mr. Fishburn, you have not only forfeited your right to live among us, but under the laws of the state of Florida, you have forfeited your right to life. The scales of life versus death in the murder of Aisha Levy tilt in favor of death. And therefore, Mr. Fishburn, I will now adjudge you guilty of murder in the first degree and sentence you to death for the murder of Aisha Levy. You are hereby notified that this sentence is subject to automatic review by the Supreme Court of the state of Florida, and counsel will be appointed by separate order to represent you for that purpose. It is also further ordered that you be transported to the Department of Corrections to be securely held on Florida's death row until the sentence can be carried out as provided by law. So, Mr. Fishburn, may God have mercy on your soul. That concludes the sentencing today. Thank you.
He later pleaded guilty to first-degree murder, and after a jury's 10-2 recommendation, the judge sentenced him to death. Levy's family mourned her tragic loss, remembering her bright future and potential. On July 15, 2013, in Madison, Jesse Blodgett became a victim of Daniel Bartelt, a violent perpetrator. His appearance in court caused strong reactions from Jesse's family. After hearing his statement, the court had difficulty deciding if he was mentally ill or just incomprehensible.
I can't give you the answers that you're looking for. You say how you count the days and the hours, and I do too. I have every day. There's no hiding from yourself in a tiny concrete cell. I have a disgustingly innate ability to lie to myself that I've exercised far too many times in my life. But I refuse to hurt someone other than myself by doing that. This jumpsuit that I'm wearing, these shackles that I'm put in, don't make me guilty. And I know there's evidence that I can't refute that would make you believe that I am guilty. I know that you feel I may have enjoyed how painful this process was for some of you, and at my worst, I've had that quality. I've made terrible mistakes along that line, but the only reason that I went to trial at all is because I was told I would not be allowed to make an Alford plea, to acknowledge that I couldn't refute the evidence and just accept sentencing without saying that I'd done something I hadn't. If I could have done that, I wouldn't have put any of you through this or my family. Judge Martins, for what you represent, I'm not trying to be combative, but I don't know whether I should fear you or loathe you. I struggle to understand someone who has, that any human should be given the ability to condemn his fellow man. But I do know that I pity you. I don't blame you for any of this. I think you've been extremely fair given what you have to work with. I can't prove that I'm innocent to anyone, not even myself. I can't prove that Jessie was a beautiful person, though she was, and I still remember her. I can't prove that a sun that I haven't seen for over 400 days still even rises and sets, but I like to believe that it does. Buck, again, I think it's incredible that such ugliness has begotten such beauty, and I've seen that from your entire family. I saw that the day after Jessie died when I was with you. I pray for you, for all of you, and I hope that, I believe that someday I will be before a court that will know that my conscience is true. I love you. I'm so sorry for your loss.
Daniel Bartelt was given a life sentence without the possibility of parole. A man from Chester, South Carolina, identified by prosecutors as a gang member, is asking for immunity under the Stand Your Ground law for an incident that occurred on Christmas 2018. The accused, Quinton McClinton, insists that he did not have a weapon the night of the incident.
Murder as well as possession of a weapon during commission of a violent crime. Your Honor, this matter comes before you today based upon a motion filed by the defense for them to raise the issue of a stand your ground defense or immunity to the actual charges pending against Mr. McClinton. Altercation did break out between the defendant, Mr. McClinton, as well as the Gregory brothers. It appears that that actual fight or altercation took place inside the club, and then at some point in time, the defendant, our position is that he, and along with some other individuals in the club, were beating up Mr. Cochise Gregory to the point where he was on the ground and they were stopping him.
Pool hall side and began swinging that, hitting various individuals. Again, I'm not sure that Mr. McClinton knows precisely who he hit, but there were about a dozen people involved who were there coming toward him and his group. And Mr. McClinton hit a number of them with the pool cue.
Mr. McClinton ran out of the club, and our position is that's whenever he did retrieve a weapon, if he didn't already have one on him. There's been conflicting testimony as to whether or not he already had it on him or if he got it from the car that he ran to, along with Montrell Graham, who was with Mr. McClinton, and at such time, that's when Mr. McClinton did shoot at Cochise Gregory and basically anyone else who was back towards the club. Mr. Gregory did get shot several times, and he did have to be airlifted and almost died.
There were taking place, as I understand it, there were from Cochise Gregory and or his folks, and there was from other individuals, from at least one other individual. In other words, it was a exchange of, but Mr. McClinton did not have a firearm and was not engaged in that. I don't think that the state's charge for attempted murder against Mr. McClinton can stand.
And when it's a not me, it's not that he's asking for immunity from the that occurred to Cochise Gregory, because this is the attempted murder is not based on the pull sticks and the kicking in the head and all that stuff. That fight had ended at that point. And then what we have is these events that led to Mr. Gregory almost dying. The stand your ground position, was he standing his ground from? He was leaving at that point. And so if he was running away from the situation and shot back, then that would be a stand your ground situation. But that is not what we have here, because he's denying that he ever had a...
Quinton McClinton was sentenced to 25 years in prison after being found guilty of murder and other charges related to the Christmas 2018 shooting. Despite his claims of self-defense under the Stand Your Ground law, the court denied him immunity. Shawn Go, a man from Stark County, Ohio, was convicted of the brutal murder of his 24-year-old girlfriend, Rachel Sheridan. On July 2nd, deputies were called to Sheridan's residence in Plain Township after she was reported missing. At the scene, deputies saw Go driving Sheridan's maroon Jeep Liberty. When they attempted to stop him, he fled on foot. The next morning, Go was arrested at a homeless shelter on unrelated active warrants for burglary, grand theft of a firearm, and domestic violence. A search of the apartment that Go and Sheridan shared revealed evidence of foul play, leading investigators to determine that Sheridan was murdered inside the apartment. On July 3rd, Sheridan's body was discovered by sanitation workers in a park in Canton, wrapped in a sheet and dumped in a location near Mother Gooseland. The murder was so brutal that a sheriff's deputy was unable to identify her based on a photograph. Shawn Go was sentenced to 29 years to life in prison for his actions.
Importantly, at the time of this incident, this murder, the defendant committed these offenses. There were 5 warrants for his arrest out of the Camp Municipal Court. 3 of the warrants were for burglary, felony of the 2nd degree, theft of a firearm, felony of the 3rd degree, and criminal damaging filed on June 17, 2024. Additionally, there were 2 more warrants for domestic violence, misdemeanor 3, and criminal damaging M2 for a case that occurred on May 3rd, 2024, and it's important to note that in the latter case, Rachel Sheridan was the victim. In order for me to sentence, I have to talk about the facts of this case. And the family, you've been through so much, but I have to do this on the record to support what sentence I'm going to give. So I don't want you to think that I don't have empathy for you, I do. But I've been on this bench 17 years, and I agree with Mr. Barr. This is without a doubt the most brutal that I've seen. It was difficult up here even listening. It's appalling. It's heartbreaking. Rachel Sheridan was beaten so severely that the sheriff deputy who saw her body couldn't identify her based on her own photo. A hammer or some type of instrument was used that crushed a 3x2-inch hole in her skull, her upper jaw being broken into 2 places and pushed into her face. Her lower jaw was also fractured. The blunt force so devastating it collapsed her cranial cavity into her brain tissue. The coroner described a portion of her face virtually exploded. There was testimony from both the coroner and detective that this type of damage could not have been done by a fist, but required a serious violent impact, which they estimated at least 10 different injuries by blows. The coroner noted the cause of death was multiple blunt force injuries to the head. Then, in an attempt to cover up your cruel and cowardly actions, you then tampered with the evidence, using some form of bleach and other cleaning devices in an attempt to cover up your guilty trail. Your deceitful conduct was further exhibited when you were stopped by a police officer on videotape due to the fact that there may have been a warrant for you, but only, and I mean only, after you advised that Rachel's whereabouts were unknown. Instead of being worried or concerned, you ran. Your devious plan didn't stop there. Later at the Refugee of Hope, you attempted to secure a free bus ticket to leave town to cover up this dastardly scheme. The senselessness of this murder tells me not only are you morally bankrupt, but you have no fiber of decency. Displaying the lowest level for human life, you then wrapped the body in a sheet and dumped it in a park near Mother Goose Land. This is the person at one point you claimed that you were in love with. Instead, you threw her in the trash like a piece of garbage. The only thing that stopped you getting away from this crime, you almost pulled it off, was excellent work by the Canton Police Department, Stark County Sheriffs, and your own one fatal flaw, keeping Rachel's phone in your possession. I'm tired of people trying to blame everyone else for their problems in life. Everybody's had a difficult life in one way or another, so I don't find that your childhood excludes anything. We seem to live in an entitlement world for some reason. But I want to make sure you understand something, son. It is my job to protect this community, and I will do so. I will do everything I can to lock you up for a long, long time. It's obvious to me that I cannot rehabilitate somebody like you with such a disregard for human life. I will now announce the sentence. On count 1 murder, an unclassified felony, I sentence you to a definite sentence of 15 years to life. As I indicated, count 2 murder and count 3 felonious assault merge. As to the repeat violator offender, that's a little bit different. That's up to the court, and you can order a sentence of 1 to 10 years. I am ordering you to serve the period of 10 years consecutive, and that would be served prior to any other sentence that you will be serving. Tampering with evidence, you will serve a definite sentence of 36 months. Gross abuse of a corpse, you will serve a definite sentence of 12 months. So since this is complicated, I'm going to walk everybody through this so you understand. You'll serve 15 years to life on the murder charge. You will serve a mandatory 10 years on the repeat violator offender specification, which is consecutive. And that'll be served prior to the murder sentence. 36 months definite sentence on the tampering evidence and the 12-month definite sentence of gross abuse of a corpse. Both of them will be consecutive to the murder and repeat violator sentences. So in a nutshell, that's 29 years to life. Mr. Go, you sold your soul to the devil. I've ordered you to receive the maximum sentence on every count due to the fact that you deserve the maximum sentence. The reason the maximum consecutive sentences are being imposed because you committed the worst form of the offense. And there's a great likelihood you will commit a future crime. I can't help you.
During the sentencing, Stark County Common Pleas Court Judge Frank Forchione condemned Go's behavior, labeling him morally bankrupt and stating that the case was the most brutal murder he had encountered. The judge highlighted the appalling nature of the crime, emphasizing Go's lack of humanity and the cruel treatment of someone he once claimed to love. Tyler Card, a former swim coach at Allen Park High School, was arrested and charged with sending inappropriate explicit messages to a female swimmer. The messages, which included requests for explicit photos, were exchanged through the Snapchat app between February and March 2015.
Mr. Card, do you wish to say anything before your sentence, sir?
Just that I'm sorry for
Can't
everybody.
hear you.
Just that I'm sorry for everybody I hurt and for the mistake that I've made.
Mr. Prosecutor, what would you like to say to the other people?
Judge, just one. I do have one correction on the sentencing information report as far as the scoring. Just so it's accurate, Judge, OV10, which is exploitation of, OV4, which is psychological injury to the victim. The complainant in this matter did seek counseling, was in counseling for a period of time. I think they've kind of reached a maximum benefit point, so she's currently not in counseling. But that correctly should be scored as 10 points, Judge. It does not make any effect on the guidelines, but I know...
Which one?
OV4, Judge.
What's your position?
Your Honor, I believe that we have the guidelines of 0 to 6 months, and I'm asking that this court...
I didn't ask. I want to know what you thought about OV4, because the argument should be 10 points.
That's fine, Your Honor. It is.
All right. I'll score 10 points there. It's not going to change the grid, correct?
That's correct.
It doesn't change the guidelines, correct?
That's correct, Judge.
Okay.
But as far as anything else, Judge, I have had an opportunity to speak to the complainant's family. They've indicated they just feel it's in their daughter's as well as the family's best interest to not appear today. They frankly just don't want to see the defendant again, and they have no other comment than that.
Okay. All right, this was a case where there was a sentence agreement, and count 1 was dismissed, which was a 10-year felony, and the prosecutor and defense counsel agreed that the defendant would plead guilty to count 2, the sentence agreement of 3 years probation, sex offender treatment, no contact with the victim, and Tier 2 sex offender registration, which is 25 years with biannual verification. Is that correct?
That's correct, Judge.
That's the full extent of the agreement between the people and defense counsel. Is that correct?
That's correct, Your Honor.
Okay. So the court is going to sentence you to the following: 3 years probation, will be supervised, sex offender treatment as directed through probation as ordered by this court, no contact of any kind with the victim, either through yourself, through any friends, relatives, obviously no social media contact of any kind. You will be required to report under Tier 2 SORA, and it'll be a 25-year reporting period with biannual verification. You must not reside, work, or loiter within a student safety zone defined as 1,000 feet of school property, developmental, kindergarten through 12th grade school, unless you meet a statutory exemption. You must submit to a search of your person and property, including but not limited to your vehicle, residence, computer, without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You must not have verbal, written, electronic, or physical contact with Allen Park School District, either directly or through another person. You must not purchase, possess, or use sexually stimulating materials of any kind, or sexually stimulating materials as defined by your relapse prevention plan, therapist, or counselor, and or the field agent. You must not enter places where sexually explicit or stimulating materials are sold or used. You must not have any relationship, romantic relationship, with anyone of the age of 17 or under unless you first obtain written permission from your field agent. The court's going to assess statutory costs. We'll take $1,300 today. The balance must be paid off in the next 6 months. The court will give you your rights to appeal. If you wish to file an application for leave to appeal this matter to a higher court, sir, and you can't afford a lawyer will be appointed to represent you, you have 42 days in which to file that application for leave to appeal this matter to the higher court. Is there anything else for the record from either side?
Nothing else, Your Honor. Thank you so much. Everyone have a good day.
After an investigation triggered by concerned fellow students, Card was fired from his position as head coach. The school district has shown support for the victim and is taking steps to handle the situation. This is Vincent Simmons, who has spent 44 years in prison for a crime he didn't commit.
Did you think you would die in prison?
Yes, and I had visions of the prison gates opening up, and I'm walking through.
Bringing you the story today of a man who has spent decades in prison for a crime he says he did not commit.
His name is Vincent Simmons.
In 1977, he was found guilty of attempted aggravated rape.
2 of us, and he put us in a trunk to die. He had me write our names down, and he told us he was going to kill us, and we believed every word of it. And we were not going to tell anyone. Our plan was we were going to do this.
Time to let him go, y'all.
When Vincent Simmons arrived at the Orleans Parish Courthouse in a prison van with his hands shackled, he carried a Bible. At the same time, his accusers, Karen and Sharon Sanders, the twin sisters he was convicted of assaulting when they were 14, walked to the courthouse and stopped to pray.
We called him Simmons all night. There's so many things about that night. He gave us his name.
When you were questioned by the sheriff,
Yes?
you never gave the name Simmons.
No, we did not.
You never described what he looked like.
No, we did not.
You said all
Blacks
in,
look alike.
And you said all in-words.
That's right. Sure did.
So how are we to square the fact that that night you couldn't explain anything? You didn't have his name, you didn't know what he looked like, but now you're telling me today, and you testified at trial, that his name was Simmons.
That's right.
How does that happen?
Okay, this is how it happens. We had all 3 swore to each other that we would not tell a soul.
May I ask you, with all due respect?
Yes.
Why did you make that pact to not say anything? Why
We
wouldn't
were
you
scared.
immediately report it?
Because we were scared. He told us that he had friends and that he would come back and kill us if we told anybody.
Simmons had been in prison for 44 years, spending most of that time trying to have his conviction reversed.
You've done this 16 times, at least.
Yes.
So this would be 17. You think this will be the time?
Yes, sir.
Simmons was about to face a judge who had recently reviewed information from 1977 that wasn't presented during his trial. He and his lawyers believed this information could have changed his conviction for attempted aggravated rape.
One of the attorneys, who was Vincent's defense attorney at the time of trial, says they never knew that the coroner said you were a virgin. That the coroner said there was no evidence of sexual assault found on either one of you.
Okay, well,
They didn't know that.
Well, it's 2 weeks later, and it's still not important. The fact is, he still attempted, and he wasn't successful, so he still raped her, and he did rape her.
So how do you react, though, when the report essentially says there
I don't
was
care,
no
because it-
evidence of sexual assault?
Because it doesn't matter. There was. Because we know. By now, I think if we were lying, we would have given up. But I'm not giving up.
In less than an hour, Judge Billy Bennett stated that there had been a failure of justice in Louisiana in 1977.
You free, brother. You free.
You're free. Done.
And that Vincent Simmons deserved a new trial.
There's no physical evidence that connects him to that crime. There's no blood, there's no semen, there's no hairs, there's nothing.
Listen, Vincent served 44 years here at Louisiana State Penitentiary, but he was supposed to serve 100. That was the sentence. For the last 30 or so years, he kept trying to tell judges, I didn't get a fair trial, and here's the information, and they just dismissed him left and right. Get out of here, get out of here. But yesterday, there was a judge who said to him, I believe that you did not get a fair trial. In fact, that judge's daddy, nearly 30 years ago, dismissed Vincent's attempt. But this judge said, your rights were denied, they were violated, and you get a fair trial.
And that's when the shackles were removed from his feet. The district attorney announced that he would not retry Simmons.
Was that moment like for you when you realized that what the judge said meant you were a free man?
Yeah, it dawned on me. This is it. You know? Man, you've been waiting all these years for this.
You'll turn 70 on Thursday.
On Thursday.
Did you think you would die in prison?
Yes. And I had visions of the prison gates opening up. And I'm walking through them.
Are you mad at anyone?
No, I'm not mad.
So you're not mad at the women?
No. I'm not mad at them. I mean that. When I told them I forgive them, that's what I mean. Forgiveness.
But before he could be freed, something unusual happened. Louisiana prison officials insisted that the shackles be put back on so he could return to prison for processing.
I'm just telling you, he's a free man. You can't be in jail tonight like that. That's not like that would not be a good thing.
He would get back in the van and make another 2-hour trip to Louisiana State Penitentiary, the biggest maximum security prison in the country. There, at sunset, Vincent Simmons walked out of the place where he had been locked up since he was 25.
Hey man, I want to.
The judge said on the bench yesterday, I want to be clear, I'm not telling you that Vincent Simmons is guilty or innocent. I'm just telling you he deserves a new trial. When the district attorney stood up almost immediately and said, Judge, we're not going to retry him, that meant the charges at that moment were dropped. When Vincent walked out of here last night, he said he wanted a crawfish dinner. So he got it. What's next for him? He says he wants to leave Louisiana and start again somewhere else.
As Simmons adjusts to a world he left nearly 50 years ago, his legal team created a GoFundMe page for him. When he left prison, all he had were the clothes on his back. Former Southern Indiana Sheriff Jamie Noel was sentenced to 12 years in prison, followed by 3 years of probation, after pleading guilty to 31 felony charges, including theft, money laundering, tax evasion, and corrupt business practices. The charges stemmed from a series of fraudulent activities involving Noel's misuse of over $3 million in funds from the Utica Township Volunteer Firefighters Association, UTVFA, which he managed. He used these funds for personal expenses such as luxury vacations, child support payments, and an extensive car trading scheme. Noel also directed jail staff to work on personal projects during county time and used fire department funds to benefit himself and his family, including his estranged wife, Misty, and daughter, Casey, who also face related charges. Victims testified during sentencing about the far-reaching harm caused by his actions, including job losses and disrupted emergency services. Noel expressed remorse in court but faced sharp criticism from the judge and victims for betraying public trust.
We have heard today that real lives were lost in exchange for your greed. Employees lacked equipment and staff to effectively perform their duties, and therefore the citizens of Clark County, and perhaps Floyd County, lost their loved ones. The town of Charleston had to find means to ensure funding for a resource officer for their schools to protect their children, again, because of your greed. You failed as an uncle and a brother in all regard. You failed as a father. I would have thought that any honorable man would have accepted responsibility for their misdeeds instead of getting your daughter arrested and charged, yet you sat silent until today. Your commitment to your extravagant greed even went so far as to steal from your nieces and nephews, your deceased brother's children. What could be more reprehensible than that? Your actions have revealed that your lust for power and pleasure are worth far more than the lives of those entrusted to you for your care, but today the court says otherwise. I have wrestled with the idea of accepting or rejecting this plea. When I was here last Friday, counsel for Mr. Miller made argument that everybody wants you to do a lifetime in prison. And maybe that's what you deserve. But the law will not allow me to do that. I asked Office of Court Services to do an analysis. Fellow up there I respect, and is probably a lot smarter than me, as to what the minimum and maximum I might be able to give to you would be. And we've had discussions about that, and I've discussed it with others and done my own research. I could give you perhaps more time, but then I would be subject to an appeal, and the Court of Appeals might lower my sentence substantially as I recently had done in Washington County. They thought I give them too much. I thought I was right, but the Court of Appeals said otherwise. You can't just take each count and add a year. There's issues concerning continuous criminal conduct and minimum and maximum and how they're tied together with all the other charges and time elements. So as I've analyzed this, I've come to the conclusion that it's a very substantial sentence, considering that these are level 5s and level 6 felonies.
Beyond the criminal charges, Indiana Attorney General Todd Rokita filed civil lawsuits to recover $4 million Noel and his family allegedly misused. The case also implicated other officials and highlighted systemic abuse of resources under Noel's management. A 20-year-old man, Shawn Ford, was sentenced to death for the brutal murder of his girlfriend's parents, Jeffrey and Margaret Schobert. The murders occurred in April 2013, after Ford had previously attacked his girlfriend, Chelsea Schobert, due to her refusal to have an intimate relationship with him.
The hardest thing has been the day-to-day. The things that no one thinks about. How many times in a day does the thought cross your mind that your mother or father would love to hear about something? A joke, a story on the radio, something you saw on TV, just some insignificant part of your day. How easy it is to call him up on the phone. Well, now, we have no one to share that with. I recently secured my first full-time job. And while I love my family dearly, I cried the day that I was hired, because my extended family should not have been my first call, but they were all that I had. The hardest thing for me has been going on road trips with friends, because invariably when we arrive, they pull out their phones and call their families to let them know that they arrived safely. The hardest thing is sitting there with my phone in my pocket, knowing that no one is waiting for that call from me. Shawn, to you I say, it has been said so many times how good they were to you. They did not judge you. They welcomed you. They loved you as their own, and they would have done anything to help you. If they were here today, they would forgive you. And I say to you that you may never know the full extent of what you've done, because what you took from this world are two people who truly saw you, as I believe God sees you, without any kind of prejudice. And that is something that you will never have back.
We messed up. We made a mistake. I hurt my family. I hurt you. Let everybody down. Wish I could just take it all back. I was a young kid, I love, man. I was blind in my love, man. Did something that I never wanted to do. I never wanted to hurt that girl. I never wanted to hurt the whole Schobert family. I was selfish. I was being stubborn. Like I always felt like things had to be my way. And things didn't go my way, I did something about it, or just try to make it my way. I made my mom cry, I made my sister cry, I made my brothers cry, I made the whole Schobert family cry.
Ford was found guilty of multiple charges, including aggravated murder and felonious assault. Despite his attorney's arguments that he was intellectually disabled and therefore ineligible for the death penalty, a judge ruled against this claim. While Ford expressed remorse and apologized for his actions, the court imposed a death sentence. Jamie Hood, a convicted cop killer, was sentenced to life in prison without the possibility of parole. He was found guilty of murdering Athens-Clarke County Senior Police Officer Elmer Buddy Christian in 2011, as well as injuring another officer and ending the life of a suspected drug dealer.
No comments or outbursts whatsoever. Unless the clerk first will begin.
State of Georgia versus Jamie Donnell Hood. Verdict as to penalty regarding the murder of Elmer Buddy Christian. We, the jury, recommend and fix the penalty as life imprisonment without the possibility of parole. State of Georgia versus Jamie Donnell Hood. Verdict as to penalty regarding the murder of Kenneth Amari Ray. We, the jury, recommend and fix the penalty as life imprisonment with the possibility of parole. This 24th day of July 2015, Cody Gunter, Workers.
Despite admitting to the attacks, Hood claimed self-defense. However, the jury rejected his claim and convicted him on multiple charges.
Juror number 7, W.J.P.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir. Juror number 8, C.E.J.G. Sorry.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir.
Juror number 9, C.A.L.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir. Juror number 10, V.R.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir.
Juror number 11, A.L.R.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir.
Juror number 12, J.E.G.
Was that your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is it still your verdict now?
Yes, sir.
Are there any matters before I give the jury instructions and release them? Anything to say?
No, Your Honor.
Anything from the defense?
I appreciate it.
That's no other matters. Ladies and gentlemen, that will conclude your service. And before you go, I wanted to tell you a few things, if I could. I'm going to let you all go before we take up other matters that don't involve you to finalize this because I'm fairly confident that you want to get back to your homes and your families. Of course, transportation will take you back there, but if you all have some other arrangements, if you want somebody to come get you, that is fine too, if you want that to happen. But they will get you back to where you were picked up, and then if you need something past that to get you to your home, that will be done. So you'll go back into the hotel and get your things, and as soon as y'all are packed up and ready, they will take you on. It's going to take a few minutes, I believe, for the last check. Is that right? In all likelihood, we'll have that done before you leave here, but if not, it'll be at the hotel before you leave. All right? Okay. Well, I'll let you go back to the jury room, gather up your things. One other thing, I also need to direct, all of my comments directed also to the alternates as well. I mean, you're here the whole time, doing what you had to do. So I will let you go back to the jury room now, and I wish you all well. It would be my intention to go forward and deal with the sentencing on these charges. Certainly I will hear from the state, I will hear from the defendant as well, if that is concerned. Yes. Anything else? What I was going to do was I need a few minutes to get my part together. Perhaps you all do too. I'm thinking 30 minutes or so we'll gather back together and deal with that. Let's say 2 o'clock. Be fine. 2 o'clock. Be fine. And deal with that. And of course there will be advisements about appeals and all that we'll take care of at that time. Anything else that we need to take care of? We filed previous notice.
The victim's widow expressed relief that justice had been served and hoped her husband's sacrifice would not be forgotten. Mark Sievers, 51, was convicted of first-degree murder and conspiracy to commit murder for the demise of his wife, Teresa Sievers, 46, in 2015. After a trial, a jury deliberated for 3 hours and recommended the death penalty.
Both assistant state attorneys are present, both defense counsel, Mr. Sievers. I'm told we have a verdict. State's ready? Defense is ready? Yes, sir. Does either side need time to talk to any of the members from either family? I mean, if you can't handle it, it'd probably be best if you wait to find out what the verdict is out in the hallway.
We have spoken with the family and they understand.
Okay.
What is appropriate, Your Honor.
Defense?
We're all set.
Okay. Bring them out. Please be seated. I'll ask our foreperson again, have you reached a verdict? If you'll please pass the verdict form to the bailiff. Thank you. We'll let the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action. State of Florida versus Mark D. Sievers, case number 15 CF 673B. Verdict form, penalty phase. We, the jury, find as follows as to Mark Sievers in this case. A. Aggravating factors as to count 1. We, the jury, unanimously find the state has established beyond a reasonable doubt the existence of the capital murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answered no to every aggravating factor listed, do not proceed to Section B. Mark Sievers is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. B. Sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes.
In the trial, Teresa's sister, Ann Lisa, expressed that she had no doubt about Mark's guilt and stated that he would never harm anyone again. Mark's family, including his mother, brother, stepsister, and stepmother, testified on his behalf, with his stepmother, Jenny Weckelman, describing him as a loving father who worked various jobs, including as a waiter and a supervisor. The defense argued for life in prison, highlighting his positive qualities, including his love for his children, difficult childhood, and charity work. However, However, the jury unanimously recommended the death penalty, citing the aggravating factors of the crime as outweighing the mitigating factors.
If you answer yes to Section B, please proceed to Section C. If you answer no to Section B, do not proceed to Section C. Mark Sievers will be sentenced to life in prison without the possibility of parole. C. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. No. Please proceed to Section D, regardless of your findings in Section C. D. Eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above as to count 1. Yes. If you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. Mark Sievers will be sentenced to life in prison without the possibility of parole. E. Jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factor or factors are sufficient to warrant a sentence of death in Section B, and the aggravating factor or factors outweigh the mitigating circumstances in Section D, we, the jury, unanimously find that Mark Sievers should be sentenced to death. Yes. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Dated this 10th day of December in Lee County, Florida.
Either side like the jury polled?
Yes, please.
One moment. I'll start with you, our four-person, your juror ID or number or your initials, please. Is that verdict, ma'am, that do you agree that at least, excuse me for a minute, do you agree that each of the findings in the verdict form is yours? Sir, your name or initials or ID number?
10.
Each of the findings in the verdict form is yours.
Yes, I do.
Ma'am, your name, initials, or ID number? Do you agree that each of the findings in the verdict form is yours?
Yes, I do.
Ma'am, your name or ID number or initials? Do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes.
And ma'am, do you agree that each of the findings in the verdict form is yours?
Yes, I do.
Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes, I do.
Anything further with the jury from the state? From the defense?
No, sir.
You're going to leave with my thanks, the thanks of the court system here today, and I really appreciate all the time and effort you've put into this case. You've been here for weeks, and it's a lot to ask. It's a lot to ask for a case of this type as well. You are free to talk about the case with anyone you'd like to. You're free to refuse to. If you need anything from the clerk, you can contact their office saying that you've been here this long, and you're going to leave with my personal thanks as well. Have a good night.
Teresa's sister, Lisa, spoke about the family's ongoing grief, acknowledging the justice brought by the verdict, but expressing sorrow for both Teresa's and Mark's families. She stated that, despite the pain, they would continue to focus on raising Teresa's daughters with love and positivity. On September 17, 2019, police found a partially eaten victim and a humanoid creature in a Rochester Hills apartment. The court has now determined the fate of Allison Weaver, who was sentenced for the cannibalistic attack in the woman's apartment. As the victim shared the terrifying story in court, everyone was stunned and the news quickly spread. Let's hear what the victim had to say.
Okay. Good morning, Your Honor.
Take a deep breath.
Okay.
And I do have to hear your voice.
On September 16th, 2019, my life changed forever. I let Allison Weaver in my home, and in return she tried to kill me. If the police hadn't shown up when they did, from neighbors calling 911, I wouldn't be here today. I have some memories of the attack that night, like bits and pieces of a horror movie. First of waking up in my own bed to find her in some animal-like crawling position, ready to pounce on me. Her strangling me, the expression on her face, until I was unconscious. The extreme pain I felt as I regained consciousness and could not move from being beaten and literally eaten alive from head to toe. I knew in my head what was happening to me, and I couldn't do a thing about it. And then she whispered the words, "You have to." I begged her, "I'll do anything you want." But she laughed and replied, "It's too late," and began strangling me again a second time. This time I saw my loved ones flash before my eyes, and I saw a bright light, and I saw the end of my life. That's all I remember until the hospital. I do remember seeing pure evil in her eyes, though, and I truly believe nothing can save her. Every hour of every day I deal with excruciating pain because of what she did to me and the countless bite wounds, including my hand. I have permanent nerve damage all over my face and body. She bit off my ear and literally consumed parts of me, like my cheek, for instance. The pain in my neck, shoulder, and back, even with physical therapy, is only getting worse. I have been trying to avoid more surgeries if possible than I've already had. Talking about this does not fully express my emotions. The hundreds of pictures of what she did to me are absolutely horrendous and disgusting to look at. I am unrecognizable in those photos, and they just begin to show what this cannibal has put me through, all the while with a smile on her face. I'm learning to live with the pain and countless scars, as well as the countless stares I receive. But what is scaring me is the nonstop visions of her demon eyes killing me, and the fact that she will try to do this again someday. No one knows why she chose me to be her victim that night. The doctors at the hospital said it was nothing short of a miracle that I survived that attack that night. In closing, I don't think it's fair that she has taken so much away from me that I can never get back. She stole a part of me. She broke a part of me. She took away my sense of safety and trust, and so much more. Everything that this thing has done to me deserves more than 10 to 15 years behind bars. I will be living with these problems, pains, images, and fears for the rest of my life.
Thank you.
Thank you.
I can't address you by your name out of respect, but what you did was important, and I appreciate you standing by that. And I appreciate you being here. It was critical, and hopefully you can move on. I hope your physical and emotional pain does ease somewhat. I know it's hard to say, but I do wish you the very best. Thank you again for helping me.
After carrying out such a horrific act, what else does the criminal have to say? Let's listen.
And I think there was a resolution that was worked out in this case to all the original charges that the defendant faced, to the maximum penalty that she can get on those charges. I've had obviously a number of conversations with the victim in this case about that resolution and ultimately getting to that resolution. I still believe that it is the best ultimate outcome for this case and for everyone involved. And I'm asking the court, having heard all that, ready for the PSI to still follow the Killebrew agreement in this case, Your Honor.
Ms. Weaver, do you have anything to say today?
I would
address me.
I would like to apologize to the victim and to her family, and also to my family as well. I do feel really, really horrible about what happened. I wish I could take it away.
Do you have any idea why you did what you did that night? Were you under any other influence but, I think it's marijuana, but also alcohol?
I think other than some prescription medication.
Prescription medication. Have you ever done anything like this? The victim started off, her statement it was like being in a horror movie. And I wrote that down because when I reviewed the PSI, and I had to read it a few times because I couldn't believe what I was reading. And then when I talked to Mr. Cabot about it, first thing out of his mouth was, it was like reading a script for a horror movie. I can't even imagine what you were going through. I've never seen any pictures from it or any photographs, and I can't imagine what the scene looked like. And I've never ever understood anyone being violent toward another human being. But I've said it, which I've never said twice in the same way, but I've been up here for 25 years, and I've seen murder cases that were not nearly as violent as this case. And I can't imagine psychologically where you were in doing this to her, and the excuses that were made for it. And then this was the first time I saw the medical records in terms of all the wounds on her body and her face and her genitalia. Horrific is not even the word for it. I mean, what man suffers unto man, we've all heard that before, but this is an abomination. And the strength that you showed, ma'am, in showing up here today and making your statement is amazing, and I appreciate it. And you should know how strong you are, that you're able to come up here and say your piece. Many others could not have done that. And I hope you use that strength to go forward. And don't let her make you any less than what you are. And that is an incredibly strong human being who has amazing support. I've said this before. I've read all those letters. You have an amazing support system who only want the very best for you. And I do wish you everything to become as completely healthy as possible in every way. And thank you again for being here. Thank you. I know you want more time than has been bargained by the prosecutor's office. But understand what was bargained for. The guidelines are lower than the Killebrew. In other words, they bargained for a higher sentence than I would have had to give reasons to go higher than the guidelines. And that's not necessary here because there was an agreement for it. And I think this is the correct resolution to this particular matter. Because I don't think that these charges would ever have intended to reflect what actually happened here. These charges are not what was seen here. So in some ways, it's a gift what these charges are. It could have been worse. And I'm glad it wasn't worse for you physically. So I will follow the guide of the Killebrew in this matter. And I do set the court, having reviewed the probation department's report and recommendation following the Killebrew does sentence you 10 years to 15 years in the Michigan Department of Corrections, 34 days jail credit. Count 2, counts 3, 4 and 5, 57 months to 10 years in Michigan Department of Corrections, 34 days jail credit, $60 DNA cost, $100 by victim's fee, $270 state cost, attorney's fees to be determined, comply with DNA testing, HIV testing, offender registration requirements, no contact. I'll just say with the victim in this matter, the name will be on the report.
Thank you, Judge.
In any manner whatsoever. You have 42 days to reject certain appeals. We cannot afford an attorney. One will be appointed for an appeal by leave. This is a plea. Mr. Lynch, if you could please acknowledge Appellant's rights for me. Mr. Lynch, if you could please acknowledge.
I will, Judge. So acknowledge. May we approach this very briefly?
Certainly.
Sorry about that, Judge.
I guess now there's some rule where you're not supposed to say attorney fees to be determined, or it's not supposed to be. Okay, I just remember seeing an email, so I thought that was part of it.
Judge, I just realized when we went through the jail credit that on the face sheet of the PSI itself, not the sentence recommendation page, where it lists the final charges, it does say jail credit for 33 days. I think to comport with the Department of Corrections recommendation, that should be 34.
We'll make that change, Your Honor.
Thank you.
What page?
It's just the face sheet.
Second page.
Allison Weaver was sentenced to life in prison without the possibility of parole for the cannibalistic attack in Rochester Hills. In September 2021, Patrick McDowell fatally injured Officer Joshua Moyers during a traffic stop in Nassau County. The case became even more intense with emotional testimony from the defendant in court. After the incident, the accused allegedly had trouble sleeping, according to his ex-wife.
I had a hard pregnancy. I was really sick. And he let me sleep while he drove. And he nudged me and woke me up. And he said, "Babe, wake up, wake up." And he's like, "I just need you to talk to me because I'm seeing things."
And were you worried about Patrick's mental health at that time?
Yes, ma'am.
And he said he was not going back to jail.
Yes, sir.
As the defendant starts talking about his crime, everyone else goes quiet, and the whole court listens intently to what he has to say.
First, I want to say to Deputy Moyers, loved ones, and fellow officers, I'm sorry for what I've taken from you. I wish more than anything I could bring him back, and if my would have done it, I would have made that trade years ago. We wouldn't be here today. This is not a plea for sympathy or for my life, so bear with me, please. This is a statement of truth because I believe I owe it to all of you people that I've hurt. I can't give back what I've taken, but I can try to help you understand why this happened and help you get the justice you deserve. Listen to everyone try to make sense of what I did, explain it away, and blame it on anything but me and my selfish disregard for that man's life. And it's made me sick to think of letting others speak for me without doing the right thing and speaking to all of you like this myself. Killed a hero, a deputy who was doing his job and doing it so well that he took one look at me and knew I was up to no good for no other reason than I wanted to get away and be left alone. He should have left me alone. He shouldn't have followed me, and he should have backed off when he sensed that something was wrong. He was clearly not the kind of man to allow bad people in stolen cars full of stolen guns and drugs, people with active warrants who were so high that reality and conscience were abstract concepts, run around in his community unchecked. Instead, he put himself in harm's way between a criminal and the people he swore to protect, which is between me and all of you. And for that, I shot him and I left him there to die. I decided I would shoot him if he tried to take me to jail before I even got into the van at the gas station. I lured him toward a dark, secluded area, and when he blue lighted me, I kept going until I found a good spot. I kept the van in drive with my foot on the brake. I brass checked my pistol before situating it in a concealed spot with quick, easy access. I tried to lie my way to freedom. When that didn't work and it became clear he was going to try and take me, I got him in the T-box and leaned out to check him with two more well-aimed shots to his spinal column, and I left him there in the street, rained and bleeding for his friends to find. I never once considered his life at all. I just can't get away. I can't live with the thought of the murder I've committed being overshadowed by my life, my military service, my traumatic experiences, or my... I don't want to die, but why should what I want matter? I let this trial go on because I thought maybe I could be convinced that I don't deserve a harsh sentence, but I was wrong. I gave my testimony and I listened to people comment that I'm remorseful, so I should be allowed to live, and that sickens me. Now it's okay because I feel bad about it. Make no mistake, I am sorry and I hate myself for what I did, but that's simply not enough to outweigh the aggravators by any imaginable standard. The Moyers family deserves justice.
When the victims' relatives spoke in court, their words carried more than just grief. They expressed anger, struggling to understand how someone could take the life of a person who dedicated their life to upholding the law.
On September 24th, 2021, I woke up to a phone call at 3 a.m. from my dad. I listened as he told me that Josh and about the damage that had been done to his spinal cord and his brain. Completely in shock, I just pulled out my suitcase and started packing my clothes. I saw my black suit. I picked it up and I put it in my suitcase. And then I turned around and I removed it and put it back in my closet because there wasn't any way that he wasn't going to pull through, right? And then I got another phone call. And my dad had to tell me that my brother wasn't going to survive being. I still remember that moment vividly. I didn't even know it was possible to feel so much grief as in that moment. Hug his parents, laugh and joke with his friends. He had so much of his life left in front of him. There are too many ways that this has been horrible to mention them all. Watching my parents suffer through the loss of their son, who they poured their hearts and souls and lives into raising and loving. And even the good memories aren't what they were. In the same moment, I think about the time we spent playing in the woods by the house. I think about holding his limp hand, trying desperately to tell him things he couldn't hear. Thoughts of us waking up early on Christmas morning, or playing together in the pool, or riding four-wheelers in the woods together are now always shared with thoughts of how Josh was. It's so horrible that it ruins everything. When Josh was murdered, this community lost a great cop, a civil servant who cared for people, for his community, and for making it a better place. I'm not the only one sharing in this loss. And when Josh was murdered, I lost my brother, and it has torn every aspect of my life into shreds.
This mother's words cut deep as she sent her child to serve the country, but the child came back as a corpse. Let's hear what she has to say.
I am Brenda Moyers, Joshua's mom.
Have you prepared a victim impact statement?
I have.
Please proceed.
When I held Joshua in my arms for the first time, I then knew my real purpose. I left my job at the hospital and became full-time mom. My quest was to love, nurture, protect, teach him values, along with his dad and God's help. We had a special bond as mom and son. Our love outshines my abilities to define it. Joshua's murder has caused such high anxieties. I've secluded myself in places and people I've wanted to see so as not to affect this case. I've been in physical therapy due to the stress caused to my body. That doesn't include how bad my husband's health, my son Jordan, Ivy, and our family and friends and officers have and continue to experience. Here's a log from my journal. It's 3:30 a.m. Not this again. Please, God, let me get a night of sleep. My pillow is soaked as I think of my Joshua. Here's another entry. Today, the red-headed officer with the Nassau uniform came through the double doors of the store I was in. He was there on a call. I wanted to run up and hug him. For that short, mirage moment of time, it was Joshua. At the 2-year mark of his death, I drove to put a plaque by the railroad tracks where he was killed. Before I could attach it and leave, a train blowing its whistle pushed by. So upset and disturbed by the train's sudden appearance, I grabbed hold of the pole, shaking uncontrollably for about 10 minutes. I made my way back to the car. It's been terrible for me. I got my husband to drive me by there a few weeks later just so I could make it by there. I used to enjoy creating crafts and making things. Now, I go to the stores and cry and buy plastic flowers to stick at his grave. He deserves so much more. I'm now buying live flowers too, because he's still alive in me. Our holidays and special occasions are empty. We would always meet together.
The jury carefully delivered the verdict in this case, knowing they had a responsibility to restore people's trust in the law when it was challenged.
Factors, we, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Patrick McDowell, in this case. Number 1, Patrick McDowell was previously convicted of a felony and was on felony probation at the time he committed the first-degree murder in this case. Checked yes. Number 2, Patrick McDowell was previously or contemporaneously convicted of a felony involving the use or threat of violence to another person. Checked yes. Number 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Checked yes. Do you, juror number 44, agree that the decisions as read by the clerk accurately reflects what the jury decided? Do you, juror number 49, agree that the decisions as read by the clerk accurately reflects what the jury decided? Do you, juror number 58, agree that the decisions as read by the clerk accurately reflects what the jury decided?
I do.
Do you, juror number 63, agree that the decisions as read by the clerk accurately reflects what the jury decided?
I do.
Do you, juror number 73, agree that the decisions as read by the clerk accurately reflects what the jury decided?
I do.
Do you, juror number 79, agree that the decisions as read by the clerk accurately reflects what the jury decided?
I do.
And do you, juror number 85, agree that the decisions that's read by the clerk accurately reflects what the jury decided?
I do.
Again, thank you, Madam Clerk. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied on juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror.
Patrick McDowell has requested a life sentence. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.